believe, and we see in you one of our most important partners here.
Into legal matters now, the Supreme Court has upheld the outcome of the April 11, 2015 governorship election that produced Governor Darius Ishaku of the People's Democratic Party, the PDP. A 7-man panel of justices of the Apex Court in a unanimous judgment dismissed the appeal that was lodged by Senator Aisha Jumai Al-Hassan of the All Progressives Congress APC, as Justice Bode Rhodes Viva, who delivered the lead verdict, affirmed the earlier judgment of the Abuja Division of the Court of Appeal, which declared Governor Ishaku as the valid winner of the gubernatorial contest. However, the Apex Court panel reserved its reasons for the judgment till February 22nd on the appeal filed by Senator Al-Hassan, who is currently the Minister of Women Affairs, had prayed the Apex Court to set aside the verdict of the Abuja Division of the Court of Appeal, which earlier upheld Governor Ishaku's election. It will be recalled that the appellate court had on December 31st, 2015, reversed the judgment of the Taraba State Governorship Election Petition Tribunal, which nullified Ishaku's election.
It's simple. The Supreme Court once again has done justice in the matter and has not allowed technicalities and other fanciful points to prevail. So on the lawful majority votes, the governor retains his seat.
We are all delighted that at last judgment has been given in favor of the incumbent governor of Taraba State, His Excellency Darius Ishaku. Now the Supreme Court has confirmed it, that it is purely an internal affair. So we urge all the parties to go home and move their respective states forward.
We thank God. We had always prayed to God. We have done our best. God knows the truth. PDP people too know the truth, that we won the election. But we don't know the reasons the Supreme Court is going to give for taking that decision to say that our petition has no merit or our appeal has no merit, but we leave everything in the hands of God.
And still on election matters, the Yola Division of Federal Court of Appeal has declared the impeachment of former Governor Murtala Nyako of Adamawa State as unconstitutional, null and void. Adamawa State House of Assembly had on July 16, 2014, impeached and removed Nyako for gross misconduct. But in a unanimous judgment by the 5 justices of the Court of Appeal, the court said the impeachment was not done in accordance with the provisions of the law, as the governor was not served the impeachment notice personally. In the lead judgment read by Justice Tunde Ayotoye, the judges agreed that Nyako was not given fair hearing. The court then ordered that Nyako be accorded all rights of the office of the governor of Adamawa State through the period and paid all his entitlements as governor while it lasted, but struck out the appeal by Nyako to be returned as governor of the state as his tenure as governor had elapsed. And the Senate has lent its voice to the call for sanctioning of over 23,000 ghost workers said to have been discovered through the implementation of the Bank Verification Number, BVN. Also for prosecution are civil servants and bank officials found to have aided the scam over the years. The Chairman, Senate Committee on Finance, Senator John Eno, stated this during the budget defense session with the Ministry of Finance, addressing the Minister of Finance, Kemi Adeosun, and charged the ministry to ensure that funds fraudulently received through the scam are recovered. Adeosun said perpetrators of the scam and their collaborators would not escape punishment, and that the dragnet would also cover bank officials that aided the theft, and added that the banks used in perpetrating the fraud would also be made to refund the entire money lost to the scam, even as she said the investigation was still ongoing. Correspondent Folashade Abdusalami reports that the minister said the ghost workers were discovered through the adoption of the Personal Payroll Information System and Bank Verification Number platforms.
When we got the matter about a certain 25 billion being, paid out to a certain vendor, a certain whatever was doing TSA. Not so much the money, as much as who paid that money. I mean, there's a requirement of the Constitution that every money should be paid into the consolidated revenue fund of the federal government. If such monies were not paid, were being maintained in the various commercial bank accounts of the MDAs, and there was now a requirement and a will that every money gets transferred to TSA.
The TSA report, as you've said, we're awaiting the Senate's report on the issue. The 25 billion that was allegedly paid out was actually incorrect. It was actually 7 points. About 8 billion. Close to 8 billion, and it's been refunded because there was no basis for the deduction. And the question as to who should actually pay the charge of the TSA, I agree with you. It is not the ministries, departments and agencies who are effectively being told to move from one bank to another. It is the beneficiary, and I think that it should be within the federal government, in either the Office of the Accountant General, well, it should be in the Office of the Accountant General, because we are the beneficiary.